Good morning to you. Make sure you're having a cup of coffee right now because we want to keep you awake throughout the webinar. It's not really exciting stuff, but I believe it is something that's necessary for all of our businesses to understand and take action steps towards protecting yourself. So, um, having said that, again, welcome. We'll kind of get moving on this fairly quickly now. A few more people jumped on. So, listen, I want to talk just a little bit about what we're going to do today and what the goal is. So we're not attorneys here, as you know that, and I wouldn't try to be one. PAGA reform is a legal and a very complicated legal reform act, along with the original PAGA law that came out. So I'm not going to dive deep into the intricacies of the law and all the different penalties and modes that you can get into. That is really for an attorney to get involved in. There's plenty of webinars out there with attorneys that will give you the legal side of it. However, we always kind of come from the small business standpoint. We're just lay people, right? We don't really get into the law because if it does get to that point where we are diving into a legal situation, then we want to get an attorney involved. And that's what we always do recommend here at Infinium, that if you do get involved with the legal situation, we can only carry you so far. But then an attorney's got to get involved. So, and the same thing with PAGA reform. Again, if it does happen to you as a business, then, the first thing, and we'll talk about this today, the first thing you want to do is contact an attorney. Excuse me. I get this cough every morning. It's very frustrating. So we're just going to dive in more to the basics of it, so you understand what it is, how much the difference is now with this new reform that came out, and then like where do we go from here, right? There are definite ways that you can take advantage of this new law. And listen, I've seen PAGA lawsuits come down the pike. In fact, we just had one yesterday for a former client, so this is fairly fresh in my mind, the way these work and the fact that they do happen. Now, this is a larger client, a lot of employees. So what I've seen so far is that PAGA claims generally come to larger businesses. Smaller businesses don't necessarily, get hit by PAGA claims that often because, frankly, there's just not enough money there for an attorney to get involved. And unfortunately, the incentive has been there for an attorney to go after these claims. So you may not do it, but I will say, as a small business, the things that you do to protect yourselves, along with this new PAGA reform and from PAGA claims are just everyday common sense, and they will protect you from any kind of class action lawsuits, individual lawsuits, whatever may come your way, and they do come your way. They will come your way at some point. I've seen it too many times in my career. So anyway, so let's get started and we'll look at this. Again, I just mentioned, for those that are just jumping on, we're not attorneys. We're here to give you more practical steps from an HR standpoint before you ever get to that PAGA claim. Attorneys will tell you all the details on the other side. So, we're here to give you some basic information. We're not going to try to dissect the legal aspects of this, and nor do we want you to act on a PAGA claim or anything like that we do legally. Make sure you always get advice, beyond what we can involve ourselves. But, understand this is essential for every small business. So we'll get into that now. So there's our legal disclaimer. Let's move on. Okay, so what is PAGA, right? So PAGA stands for Private Attorneys General Act, right? And it was enacted back in 2004, and basically it deputized employees to act as private attorneys, enabling them to file lawsuits on behalf of themselves and other employees. They can involve other employees with their lawsuit because if they're affected, likely other employees might be as well. And this is all basic labor code violations, right? Wage and hour, overtime, meal break issues, final pay, work off the clock, things of that nature, all wage and hour stuff, all stuff that is very, very fixable and preventable. Okay. So enforcement, PAGA basically shifted enforcement of labor law, compliance from counties and states, labor divisions, labor standards division, enforcement division. They gave it to employees to bring those claims directly to the courts, and usually involving an attorney. Almost always. I've never seen an employee file a PAGA claim. It doesn't happen, right? This was an attorney-centric law. And you guys have many of known me. My HR career goes back to 1994, so I've been doing this for a long time. Been to labor board court many times. We used to go up to Riverside and San Bernardino, and we'd sit in front of an arbitrator basically, and we'd discuss the merits of the complaint from the employee and what the employer's side was. Usually the arbitrator would pull each person aside in a separate room. We'd walk down into the storage room. It was very informal. And it's like, well, Mr. Employee, what do you want for the claim? And Mr. Employer, what are you willing to pay? And we'd work out a settlement. And it was usually very low 4 figures and sometimes 3-figure settlements, right? Here's $500, here's 1,500. It was very simple. That's what it looked like before, and now it's evolved now to have attorneys involved. The penalties now. This is going to explain to you why attorneys are involved. So the law imposed civil penalties, sharing 33% of the penalties with attorneys. So if you was $100,000 settlement, attorney gets 33 grand. Whatever's left, 66% that's left, 75% goes to the state labor and workforce development agency, and only 25% to the employee. So do the math, and you can see where the incentive is for attorneys to really ramp these claims up and try to basically pull as many employees into it as possible, put as many claims as possible into the mix. It was a very dangerous situation. And it was applicable to anything, there's labor code violation, wage and hour, as I said, meal rest break violation, misclassification of workers, along with AB 5, as we all know, payroll errors, wage statement violations, you name it. So it involved a lot. And usually from what I've seen, when attorneys get involved, they throw everything but the kitchen sink, because it's now up to you as the employer to prove this. And it's a lot more difficult to prove if all these little technical violations. So what happened to, before, like I said, I kind of mentioned this a little bit, but it was all state enforcement. Department of Labor Standards Division and the Labor Workforce Development Agency were primarily the enforcement mechanism. There was very limited resources. They didn't really put a lot into this. It was very inefficient. As I mentioned, I remember having, negotiations in a storage closet. So it was really not very well put together. There was no civil penalties. So, now there's punitive and civil penalties that can be stacked on top. And you got to understand that word stacked. When these claims come through now, there's penalties stacked on top of penalties, stacked on top of penalties. So it does get very expensive very quickly. And they're only employee complaints. They can only file with the DLSE, and then the DLSE would decide, hey, you got a really big case here, and you should probably go talk to an attorney. Or they, like I said, most cases were settled in that little arbitrator's room. There was no employee representation. I've seen a few times when an attorney would act or somebody else would act on behalf of the employees, but generally that was not the case. Excuse me. And there's limited legal resource. There was fewer pathways to seek justice for minor technical violations, right? These were usually somebody wasn't paid overtime, somebody didn't get their final check at all, or it was 3 months late. Very blatant legal issues. It wasn't technical violations, and that's a key term we'll talk about a little bit more in this presentation. But anyway, that's all before PAGA, and then after PAGA came, as I described the law, the way it worked, and it pulled attorneys in. It basically gave the attorneys almost like a class action power, where they could pull all the employees in from a particular company and get the discovery power, which allowed them to look at paycheck stubs and payroll reports and personnel records and everything else. They basically could just kind of pull everything into that claim if they felt if it was necessary. Rarely did you just get one employee, a suit on behalf of just one employee. It was more involved. So before that, employees could avoid arbitration agreements. So even if you had an arbitration agreement, and I know in California, it's been kind of back and forth over the last few years, Excuse me, I'm sorry to be drinking coffee while we're on the thing. I hope you're having a cup of coffee too. I feel like I'm here just we're just chatting, so I hope you don't mind. Um, so yeah, so you couldn't use an arbitration agreement, and it wouldn't protect you, right? So there was no requirement for harm. And again, this is PAGA before reform. I just want to make that clear. So there was no requirement for harm. The employee got all their money, everything was fine, they got paid, but there was technical violations. Maybe there was a meal break issue where they took a meal break 2 minutes after the 5 hour mark or 6 hour mark on a Saturday, which I've seen lawsuits based on that. Maybe it was a a wage statement violation where the company's address wasn't correct. They moved and they never updated their system. Minor technical violations could turn into tens of thousands of dollars of settlement claims, which you have no idea how many businesses this has damaged and maybe even put out of business. And of course, and as I've told you folks many times before, the high litigation cost for any of these cases is cost prohibitive. It doesn't make any sense to go to court because number one, as I mentioned, the labor attorneys would, or the plaintiff attorney would throw everything but the kitchen sink. So you now have to defend yourself. You almost were guilty until proven innocent. You had to defend yourself against every single violation, whether real or not. And so you would spend hundreds and hundreds of thousands of dollars to try to defend this claim. Now, even if you won, this is the key. Even if you won in California, you cannot go back and get your attorney's fees and expenses. So you would win, you'd spend $300,000-$400,000, you'd win the case, but you're out a couple $100,000. So didn't make any sense to do this. And typically, they were just settled, right? Employers were forced to settle. And then it became a cat and mouse game, right? I want $5 million. Well, and I've seen those numbers thrown out. Well, $5 million. Okay. Well, how about 100,000? Okay. How about 150? And it would just basically come down to how much you were able to pay and what that attorney was willing to settle for. It didn't matter. The merits of the case didn't matter. The amount of the violations didn't matter. It was only about how you could get away with settling this claim as best as possible. As I've told you guys before, in our staffing company, I'm out about, our company's out about $250,000 over the last 4 or 5 years for claims like this, and they were all technical violations. Nobody was hurt. We don't hurt anybody that works for us. It's pretty bad situation. So there was a very high potential for attorney abuse of process, right? And I'm not going to point fingers at anybody, at any good attorneys or bad attorneys, but when you get 33% of the claim and the employee gets 25%, do the math. Okay, so that's what it used to look like. That was the challenges. But so now when this new Reform Act came in, and as you guys may know, I'm not a fan of government too much. I have a lot of I've got kind of a jaded, thought process when it comes to the way government regulates small business, especially in California. But I will give some credit to the state of California, to Governor Newsom, for putting this reform in, because it really gave a lot of grace to employers. And this is really important to understand how you obtain that grace. It's not free. It's not automatic. There is a process to it, but we'll talk about it. So now this new PAGA reform basically limits the scope of the employee lawsuits, right, for labor violations. It emphasizes arbitration. So now we're back to official arbitration, not in the storage room closet. And it does allow for alternative dispute resolution. So, it really, we'll talk about it more, but you definitely should think about putting an arbitration agreement in. Excuse me. And I'll tell you guys how to do that. So reduce penalties. So this reform includes caps on certain penalties, and it really narrows the type of violations. Like little technical violations really aren't part of this anymore. If you can prove essentially in the beginning of the claim or in the beginning of the process that they were technical and you fixed them, you can almost avoid penalties altogether. But even if you did get stuck at the end of all this with penalties, they're capped. It's like $100 a week, and it used to be much more than that. So a lot of this it's all about kind of preventive, but also reactive after something happens, and to correct those violations. But that was good. And that's where the part of the legal side, as I said, I'm not an attorney. I'm not going to get into this in detail, but a lot of those things, a lot of the details in this law, you probably should understand it at some point. So there's employee opt-out rights too. So if an attorney comes in and wanted to great gather, 20, 30 employees at your business, some employees can say, no, I'm going to opt out. I really don't want to be a part of this. I don't have any problems. I love my boss. I love my business, the company that I work for. So really focuses more now on let's go after the individual rather than try to pull the whole business in. So that gave us some protection. Um, and the state's involved now. So what this does is this pulls the Labor and Workforce Development Agency back into the process to have oversight. And they have now the authority to kind of jump into a claim and say, wait a second, Mr. Attorney, you're looking at technical violations. This employer has shown that they've been able to correct those violations. Nobody was harmed. We're not going to allow this to go forward. So the state kind of steps in to try to protect the employer in a way. They have the right to do that now, the power to do that. And then it encourages compliance programs. So businesses that maintain proactive or certified compliance programs, I'll talk more about that later, may be shielded from certain PAGA claims. That line right there is why we're doing this webinar today. This is the most important part of it, is that if you just put very common sense, simple things that you should be doing anyway into place, you can really protect your business from these claims. Now, I will say, this is PAGA. So an attorney does not necessarily have to bring a PAGA related claim against your business. It could just be a simple settlement demand that they push for. They find one employee that's got an issue and they can threaten class action, they can threaten PAGA, and they can still come after you. So when you do these things that we're going to talk about today, you can protect your business from all lawsuits, which is really a good thing. And by the way, I see there's one question up here. If anybody has any questions during this, we'll catch those at the end. So go ahead and place those questions up there. And by the way, just a little bit of like housekeeping. All these wage and hour things, and we're going to talk about it very briefly today. I'm not going to go into it too deep, but next month, if you want to check our events page, Infinium HR Resources events, we've got a deep dive into wage and hour violations, wage and hour compliance. So we'll get to that next month. Okay, so let's move on. So now how do we leverage PAGA, right? So evaluate current practices. And at the end of this webinar, we're going to be sending out a checklist that you can go through that will basically cover just about everything that you need to really evaluate, all your payroll, timekeeping, employment practices, and make sure that they're compliant. So that's something that I think everybody should do. And we'll kind of give you some guidance on how to do that. Implement compliance programs. So there's something in this law called they're encouraging employers to put together a certified compliance program to reduce liability and benefit from new PAGA protections. Now, there's not a lot of detail about this. Okay, so what is a certified compliance program? The best that I can tell, it is that a third party comes in and basically audits your HR and audits your processes, your wage and hour processes. And then they would file some sort of a certified letter that states that, we've done that, along with some sort of a checklist and some proof that they've looked into all the various areas of your business. You would think an attorney might be the best one to do that. I kind of think that too. We are looking into what can we do and what can we offer here at Infinium to help our clients with that. Of course, there's going to be an expense to that, obviously, but with an attorney, it's going to be 4 times that what we would charge. So we're looking into this. I'll get you guys more information on that as soon as possible. And then use alternative dispute mechanism. Ensure that you guys have some arbitration agreements. And again, we're going to provide more information about that very shortly. We partner with several law firms that we're going to work with to hopefully reduce the cost of that and sort of have one sort of a blanket arbitration agreement that then can be easily customized. So I will get information on that as quick as possible. Regularly audit employment practice. So after you've done that initial evaluation, you can use the same process and maybe an abbreviated one to go back and do a regular evaluation or audit, maybe every 3 months or every 6 months. Probably 6 months would be enough because laws don't change that fast and your practices probably don't either, but definitely want to do some regular audits to check everything out. And get legal counsel in, work with legal experts to understand what it's about. Again, I don't know if you need to spend too much time, because I would rather have you spend an ounce of prevention is worth a pound of cure, right? So let's do what we can to make sure that we are compliant rather than have to worry about the legal side of it. And in all my 30 years, we've definitely seen some lawsuits. And because our staffing company was kind of a big fish, we got taken advantage of a couple times for technical things, but um, it's definitely worth a lot for a small business to put that investment into compliance. Okay, so those are the general things about the general ideas. Now let's talk about a little bit more detail. I'm going to go into some detail on the basics of compliance, all the areas that you need to really think about. Again, this is not going to be a deep dive. We're going to do a deep dive next month. Okay. So first of all, overtime and regular rate of pay. Oops, what did I do here? Excuse me. I hope you still got the screen here. Hit the wrong button. Okay, overtime and regular rate of pay. Regular rate, excuse me, just a minute. Regular rate of pay in California requires that you pay overtime, your sick pay, and meal break violations at basically an average rate of what the employee made during that week. Now, this is only important if you pay, and I'll probably let me put a couple more bits up here. So, it's if you have multiple pay rates, like let's say you have a training pay or drive time pay, or somebody works in two different positions during the week during a pay period, that would be applicable. If you do discretion, I think I have this wrong. If you have, yeah, that's right. If you have non-discretionary bonuses, that means an employee gets $2 for every widget they build, or if the company makes a certain amount of money at the end of the week, or produces a certain amount of material or product, they get a dollar amount, right? So that's a non-discretionary bonus because it's not up to you to decide at the end of the week. There's criteria in place to pay that employee the bonus. And then you have commissions. Commissions, again, that is a non-discretionary payment, or any kind of other compensation that an employee gets that's variable paid during the week. You have to average all that out, divided by the hours that they work, and then that comes up with an average rate of pay for that period. Then on top of that, you pay that premium rate on any overtime. You pay it on for sick pay that was in that particular pay period, and then you also pay it for meal break violations if you have any. So that's regular rate of pay. It's very important to understand that when you are, overtime is a lot of people have overtime for hourly employees. If you have any kind of variable pay, make sure you're looking at this. We've done some things recently. A new blog went out. Our system does this automatically for you. So if you are using our timekeeping, we can build that for you. If you're not, we can still do that as long as we have the right information. Hours worked per pay rate, things of that nature. And I'll say our system is having a little bit of difficulty calculating this correctly. So we're working on some steps right now to make sure that that's done. In fact, I have a call today with a software company to make sure that that is being done right. Okay, so what can you do? So audit overtime calculations, make sure that, it includes all those forms of compensation for the regular rate of pay. Ensure that pay accounts for bonuses, commissions, shift differentials. Again, shift differentials is like if they have two different rates of pay. Implement an automated timekeeping system to minimize errors. That is incredibly important. We're going to talk a lot about that next week. If you aren't using some kind of electronic and accurate timekeeping method, you really got to put that in place. It's not very expensive. Super important. So just basically, our compliance tip is automate your timekeeping, automate that blended rate process, and all those wage calculations should not be done manually. Let the system do it, and double check it, audit it, make sure that it's done right, but definitely get that automated. Okay, so what else you need to do? So let's talk about meal and rest breaks. Again, most folks know meal and rest breaks. They must receive 30 minutes, at least 30 minutes of unpaid meal break for shifts over 5 hours, and a second meal break for shifts over 10 hours. And breaks have to be duty free. They can feel free to leave the premises, go wherever they want. Don't ask them to do anything. Don't ask them to check up on an email really fast or ask them any questions about work. Just let your employees be for that 30 minutes. I make a point of this. If I ask somebody, like I can see out of my office, I can see the payroll team, and I'll yell and say, ask a question, and And then I kind of look and I realize the time. I'm going, oh shoot, are you guys on lunch? Yeah. Okay. Never mind. I'll talk to you later. Just don't even bug them. Rest breaks, again, paid 10-minute rest break is required for every 4 hours worked or major fraction thereof, typically taken mid-shift. Now, had some questions about this recently from a client. Well, what if they only work 3 hours, or they work 2.58 hours or whatever? Do they need a rest break? I'm just going to say, let them have a rest break, even if it's close to 3 hours, 2.5, 3 hours. I think they need to get a rest break. If they want to take one, make sure that they have the ability to. You don't restrict them from that. Let them take those rest breaks. If they're working 4 hours, obviously try to get one right in the middle. We've started with some new clients beginning of the year, and they kind of bundled their rest break in with their meal break and made it a long lunch break instead. Don't do that. That's not going to work. That's considered a meal break, and now they've missed their rest break. So be very careful about that. Make sure you communicate it regularly to employees, and that'll help you in that area. If you do miss a meal break or a rest break, pay them the 1 hour. It's called a meal break violation. Pay them that extra wage. And again, that is paid at that regular rate of pay. So you got to make sure you remember that. But pay them that 1 hour. It's worth the hour. Even if they did it and they knew they shouldn't take a short lunch or miss a lunch, they did it on purpose, pay them the 1 hour. And then if you want to discipline that, if that keeps on happening after, continued communication and verbal, warnings, then you can discipline them for that. Now, we hate to discipline employees that want to work and don't want to take a lunch, but we have to do that. Okay. So it's really, really important that you just do those things and don't worry about the hour. It's not going to kill you. So what can you do? Basically, review and reinforce break policies and with all supervisors and managers. Make sure your supervisors, your managers, anybody you've got that is down beneath you understands that it's really important to do this. It's one of the major things that cause lawsuits. It's meal break violations, and it's very easily provable if you have timekeeping that you gave the meal break. And it's also very challenging if you don't, right? If you can't prove and that employee's got a verbal statement or a text or an email that show that you're not providing those, then they've got you. So use timekeeping software to track and document breaks. Whether you're using ours or not, that doesn't matter. As long as you use it, that's what's important. Train employees, make sure that they know that they can take those uninterrupted breaks and meal breaks and rest breaks. So make sure your employees know that. The more you communicate it in your handbook, posters on the wall, verbal, email, whatever you need to do, that'll show up in court. You can prove, hey, listen, we've done everything we could to let those employees know. This one little minor violation of 2 minutes short on a lunch, we did everything we could to prevent that. You're probably going to win. You're going to be okay in a lawsuit. And we're going to dive deeper into this because there's some issues that came up this week regarding time card edits. And we'll talk much more about this next month. But if an employee edits or an employer edits a time card, like let's say an employee forgot to take lunch or forgot to clock back in or whatever that is, make sure you get the employee's approval that they, at the end of the week, they approve the time cards. And that way you've shown them any edits that you made. They've had the opportunity to approve it, and you're good. You can also set up attestations at the end of the day that employee has taken all their meal breaks, they've taken all their rest breaks as required. You can do that as well. So that's important. Okay, moving on. So compliance step again, pay those meal break violation wages for any missed breaks promptly. As soon as you know about it, just pay it, get it over with. Okay, I'm going to see if there's a couple questions came through. So okay, there's nothing that's critical right now. I will get to these right after, guys. Don't worry. What else you need to do? Okay, so the next big one, misclassification of employees. We all know about AB5, independent contractors. So there's an ABC test, real easy. If you have independent contractors at all, number one, you need to really do an audit of whether or not that employee is, or that worker is an employee or not. So the ABC test is very simply, do they operate independently, right? So they can do what they want, come when they want, come to your office and work when they want, do whatever they need to do. That's independence, right? B, do they do this work outside of, is their task outside of your usual course of business. So if you make widgets and they're just making widgets out of their garage on their machinery, maybe they're still they're an employee. They're not an independent contractor. And they also have to have basically a business, right? So they actually do this as a business. They do it for other companies, and that's what they do. So pretty strict, pretty clear cut whether or not an employee is an independent contractor or not. And again, uh, just one of these violations or one of these, if you miss one of these, they're an employee. So you can't get out of that. And then there's exempt employees. Salary employees must earn at least twice state minimum wage for full-time employment and perform job duties that meet the professional requirements, executive or administrative. So they need to be like either like a controller, maybe they don't have any employees, maybe they're a computer technician, or a computer software professional, or management, or they're a salesperson. So make sure that you've looked at everybody. They're all meeting the exempt salary requirement. Otherwise, they're an employee and they need to be paid hourly and meet all the wage and hour requirements. So what do you need to do? Reassess any independent contractors against that ABC test. Very simple. That's something I recommend right away. Review your exempt employees. Make sure they at least meet those requirements. If you're not sure, feel free to reach out to us, and we can take a look at it and help determine. And then correct them. If they're wrong, correct them as quick as possible. If there's any back pay owed, pay them the back pay, right? How far you go back? No, I'm going to say 4 years because that's how far the law is going to go back. So, unfortunately, that would be a big mistake, a very expensive mistake, but it's something you've got to get it right and set things straight going forward. Again, and that's where, let's say you got a PAGA lawsuit that came up and you had a misclassification employee that went back a few years, but you took the steps to pay them before you ever got a PAGA lawsuit, not when you have it. You could pretty much avoid that lawsuit altogether because you corrected the issue, you paid all the back pay, you're likely not going to have any issues. And that's big because if you have to correct those violations, whether they're any of these issues that we've talked about so far, you correct them during a PAGA lawsuit, now you've got all the punitive damages and the civil penalties on top of that. Now, again, they're capped, but if there was intentional malice and you didn't really take the steps to correct it, your liability kind of goes through the roof. So it's very scalable upon how much you did ahead of time as preventive, how much you did corrective, and how quickly you did it. Right? It's all dependent on that. So it's very important to get it right. So update any contracts, job descriptions, make sure that I really recommend you have some sort of an org chart. You have everybody kind of lined up, make sure you understand what their pay range is for each position. That's the pay equity law. We'll talk more about that next month, and get good job description on everybody. Make sure you got that all together. And again, we all have businesses to run. I go through HR stuff. I can't even talk about this stuff with my wife, to tell you the truth, because it's all very boring and very technical and detailed. But you know what? Unfortunately, we live in California, and it's a great state to live in and do business in most of the time. But we have these things that we have to comply with. So it does take time. And I've said it before, you've got to be a deliberate employer, not only with your employees, the way you treat them, but the way you take care of your compliance issues. So very important to understand all these. All right, so avoid blanket classifications. If all these folks, I have this whole group of salespeople and they're all independent contractors, that doesn't fly. So just make sure you really look at each individual position on its own merits. All right, quick coffee break. Okay, so we're gonna get involved like in timekeeping, right? So make sure you have accurate timekeeping. You can really take care of a lot of these issues with good timekeeping. And if you've got a time card that folks write out, I don't think there's too many folks that do this anymore, but if the employees write out, I showed up at 8:00, I left at 12 for lunch, I came back at 12:30, and it's the same every day, any lawyer or judge is going to go, no, that's not real life. That doesn't happen. Obviously, they have worked off the clock, or didn't take enough lunch, or didn't take their lunch altogether. Make sure that you've got that very accurate and detailed with timekeeping software. And this liability protection, so it demonstrates adherence to labor laws. When you've got this, it reduces the risk of PAGA claims or any other complaints and claims. Um, and it really reduces your penalties that you've got something in place and it's documented and you can prove that you're innocent. And like I said, it's defense, right? It gives you essential defense. It's really difficult to prove a meal break if that employee clocked out, on time, stayed out for at least a half an hour, and then clocked back in. And our timekeeping software will allow you to put a restriction on 30 minutes short of a 30-minute meal break. So they will not let them clock in less than 30 minutes. Another way to prevent less than 30 minutes is make your lunch 45 minutes if it's a half an hour now. 35 minutes. Just make sure there's a little bit of buffer zone so that people don't clock in too soon. Okay, so action steps: implement reliable timekeeping tools. Again, I don't care if you use our system or not, use somebody's system and make sure that you've got that. It just makes it a lot easier when it's integrated with payroll. And I think our system works pretty well. Train employees on the importance of accurate timekeeping. If you see, again, during these audits, this is why we do these audits. If you're not doing it every single week along when you process payroll, then do it periodically. Make sure that employees are clocking in, that there's not any lingering issues where employees always clocking in, short for lunch or late for lunch. Don't allow that to continue. Make sure you're looking at that very regularly. Monitor off the clock. First of all, don't ever allow an employee to work off the clock. Like, oh, I'll take that. Like we have employees that'll leave and they'll take the payroll to FedEx or wherever on a payroll delivery day. It's like clock out after you drop the payroll off. Don't clock out now and then drive home, because that's working off the clock. So be very careful. Don't contact employees off the clock if they're hourly. If they're salary, then that's a different story. But if they are hourly, don't require any work off the clock. Very, very important. So just keep digital records, simplify audits, keep these things for about 4 years, your digital records. And, in our, sometimes software, if we don't have clients that leave us too often, thank God. But if you do leave a payroll company, make sure and I've got some folks in here probably aren't our clients. Make sure you print out everything that you've got for those last 4 years for every single employee. You can save it electronically. Make sure you're tracking it. Don't depend on that software company or the payroll company to provide that data to you. That's usually like pulling teeth. So protect yourself, get all those records and keep them someplace. Okay, so wage statements. Wage statements are based on paycheck stub, right? So you got to include the employee's name, address, gross wages earned, total hours worked, deductions, net wages, pay period dates, and the employer's legal name and address. Don't put your DBA or a fake DBA on your paychecks, right? Make sure that your legal name is on the paycheck, your address. It shows up on not only on the paycheck stub, or the third section of the stub, but it shows up on the main part, and it also shows up on the paycheck part. Our checks are pretty compliant, so I wouldn't worry about too much about that. But it's just something I've seen claims go wild over a very technical violation. So make sure they're correct. And a lot of times, by the way, you get wage statement violations with a lawsuit, and it's because you didn't include your meal break violation. You didn't pay them overtime. You didn't pay them whatever. So the wage statement isn't correct now because they didn't get paid properly. So this is the stackable part of these claims. So just make sure these things are detailed and they're right on. All your hourly rate details. Again, if there's a blended rate or a regular rate of pay, make sure that that's detailed out, how those things were paid, sick time, meal break violations, overtime. That should all be detailed. Multiple pay rates should be detailed. That's all got to be on the check. Accurate, they're accessible. Make sure that the employees get a copy or they have a copy electronically. It's up to them. You can't force them to have that electronic copy, but make sure that they're all provided to the employee and they have access to them. So action steps: conduct regular audits. Again, just double check everything. It's worth it. Maybe this is only a once a year thing, right? So your software changes, whatever. Check at the beginning of the year, make sure everything's correct. Make sure the employees have them. Again, we can give them electronic access to our system. Always have them at their fingertips. And then if you do notice something, fix it correctly. That's been a theme we've been talking about. Don't allow those things to linger. Okay, might be on the last here. So employee complaints. This is not like a wage and hour kind of thing. I'm not going to be able to fix this with a, a timekeeping software, but if somebody complains, take it very seriously, document it, acknowledge it, make sure that you do some sort of an investigation to find out, well, is there an issue here? Is something we need to worry about? But definitely take it seriously. Don't just brush it off, and make sure your managers know. We've seen some issues come in, not so much related to wage and hour violations, where an employee complained to a manager. That manager thought, "Oh, this is not a big deal. I think everything's okay." Now, even the employee might have said, "Hey, it's fixed now. I didn't get my overtime a couple of weeks ago, but it's no big deal." That manager needs to take that seriously and now bring that up to upper management. Don't brush those things off, and address the labor law violation. Talk to us, talk to HR, talk to attorney, and fix the problem once you know it's there. Again, and I'll kind of get ahead of myself, sorry, but put a proactive resolution. So resolve this internally whenever possible. Don't wait till it gets to a law claim, a legal claim. If it is part of a legal claim, obviously there is mediation opportunities when you contact the LWDA, the Labor Wage and Division Department Enforcement. I've lost all the names now, but when you do contact them, you can provide proof that you've corrected something. Like, even though it was wrong, you can provide them proof that may help you prevent a PAGA claim going further. And having those records is very, very important, right? You can't go back and try to recreate records that aren't there. Make sure you've got them, that you can prove your innocence or your corrective process to anybody in a defense of any claims. So action steps, create a clear process. So maybe we go back to the employee complaint box, right? That's on the wall. But more practically speaking, let your employees know that you have an open door. Very important. Anything that you feel is wrong, is a problem, bring it to our attention. We will address it. We want your input. We want your feedback about our business. And that goes with anything. I don't care if it's your culture or the way you pay employees or any kind of workplace environmental issues, like environment issues. Make sure you listen to your employees. Okay. So that'll solve most of that. And then document everything. Again, address it, acknowledge it in writing, whether it's an email or a letter, and that you're going to take action to address it and what you're going to do. And then again, provide training to managers. Make sure that they know that we're going to be releasing. We've had it in the past where we've updated it now, but by next month we will have our HR 101 for managers. So out of that or that wage and hour deep dive that we take next month, we're going to be providing online training for your managers. And if you're with our HR program, that's free. If you're not, I would really encourage you to be a part of our HR. It's not very expensive. You get harassment prevention training, you get workplace violence prevention training, leadership, which is now being released, and also the HR 101. So really good, important things that your employees need to know. And we can help you with a lot of this compliance issue. So final compliance tip, just resolve issues quickly and internally to reduce your litigation, and document everything that you've got. Super, super important. Okay, so I talked a little bit about like this certified program. Again, we don't have a bunch of details about it, but definitely just conduct an audit. And you'll get this checklist after this is over when I send out the recording. You can start doing an audit, and you may not complete it. There may be some things that aren't applicable to what you do, but at least you've shown an effort. Hey, I've gone through the checklist. We've double checked everything. Here's all our backup documentation. Here's how we do things. It's a step that you got to take. That's not necessarily a certified program, but it definitely could be the start of it. And then you can have an outside firm confirm what you guys have looked at. Develop clear policies and procedures for addressing all these areas. So just make sure that you've got a process on how you're complying with everything. Provide ongoing training, as we just mentioned, with using HR 101, or you can just talk to them and bring this up to them. Have a good internal process for reporting and for resolving any complaints, as we just discussed. And then, partner with somebody like us. So like I said, we'll put some information out on what we can do to help. There might be a little expense to that. We're not trying to make money at this stuff. We just want to make sure our time is covered, and we provide some sort of a way for you to resolve some of these issues. Okay. So that's a lot of the preventive. And again, I didn't get into tons of detail on this, but I hope you get the basic premise here is that you've just got to be doing this stuff right, and you'll avoid a lot of issues. But something does happen, right? So what do you do if you got a PAGA notice? I just saw one yesterday. I think I printed it out. I can probably show you what it looks like. Maybe not, but yeah, we just saw one come across again because it's a former employee, so a client. Anyway, first of all, just take it seriously, right? This is a legal process has now begun, just like any legal notice that you receive. You can't bury it. You can't try to fix it on your own. All right, just carefully review it, figure out what's going on, what are they claiming, and the one I saw yesterday, it's the same process. Everything in the kitchen sink is thrown at the wall. Okay, so that this is what they do. So understand that, and you've got to probably, I'd bring an attorney in immediately. Do not try to do this on your own. We cannot help you, unfortunately, because we're not an attorney. We've got great law firms that we work with. If you need a referral, if something ever does happen, please contact us and we'll help you out with that. Notify key personnel, so managers, anybody that's going on. Hey, this is what's happening. We've got a claim. We've got to go ahead and start doing some due diligence to pull the information that we need to either prove it or dispute it or whatever it, or correct it. So get everybody involved, get your team involved. And then again, now you're going to do sort of an internal audit, right? What are they claiming? Do we have any violations that we have to deal with? And basically what is our potential liability? Are they really, really bad? Are they technical violations? Do we actually not pay somebody right? Usually they're going to be technical for most companies that I see, but you never know. You might have more, you might have done some things wrong that you weren't even aware of. Explore settlement options. Again, there's going to be a process that you're going to go through to contact, acknowledge receipt of this. You've got 33 days. I think that's coming up here. I got a couple weird things. So you got to respond to them within 33 days, and that starts the process. A lot of your information is going to go to the LWDA. Your attorney should be putting that together. Your attorney should be responding, not you. And then you can begin to implement those corrective procedures, measures, and show them that you've done that. So there's a process to it. Prepare for potential litigation. It may come out. Let's hope it doesn't. And I believe there's a lot of grace now. So hopefully you can avoid that at all costs. But then, begin to put things in place. If there was some issues, now let's correct what we've gone through, and let's make sure that doesn't ever happens again, right? So we can learn from our lessons. Hopefully it's not as painful as it could have been before, but if you ever get these, and we have not seen a lot of our clients get these. I've seen very few over the years. I've seen more settlement claims, okay? And again, I've received them myself. We've had some clients that have received them, and usually it's just an attorney that's threatening PAGA or threatening class action, and they're just trying to get as much money out of you as possible. So everything that we just went through and what we'll go through next week is going to really put an insurance policy on your business to protect you from this. I'll also say, mentioning insurance policies, I really, really recommend employment practices liability insurance. It's not very expensive. I've got some great resources for that, and I will send those resources to you along with this, with the information we send out. Just to give you an idea of what that does and what it costs. So in our staffing company, I think we did maybe 3 or 4 million in payroll maybe last year. So that policy cost $13,000. Now it's a lot of money, but the protection is there's a deductible of up to $50,000. So I'm still on the hook for $50,000. Okay. But beyond that insurance is now going to kick in, and they provide their attorneys as part of the process. So their goal being the one that's going to have that, maybe that future expense beyond 50,000, they've got a really, really strong incentive not to run up the legal bills, get this thing settled as quickly as possible, and protect the business. So really, really encourage you to look at that. I will send information about it. Maybe we'll do a webinar on it soon, along with some attorneys to tell you about it, but it's something you might want to think about. Okay, so again, the checklist, we'll get this out. You'll receive this with a slide deck and the recording of the webinar, and I'll get you some information on EPLI as well. HR 101 training will be ready next month. I promise. If I have to work, we have to work on the weekends to get it done. We'll get this done. And again, please don't forget our February webinar, which will do a deep dive into wage and hour compliance. And I think we've been beating this dead horse for a long time about wage and hour and timekeeping and protecting yourself. But I believe it's extremely important. I don't like lawsuits. I don't like paying attorneys money unless it's preventive. And so we really want to protect you and help you in your business success. And, there is a whole nother side of it. I think towards probably the end of the first quarter, beginning of second quarter, we'll start doing some webinars on culture and building a real team oriented workplace. And it's part of a deliberate process. But if you have a good workplace and everybody's on the same page and they all believe in the company's vision and they enjoy working for you, you're much less likely to have problem with claims. Now, you still may have issues. We're dealing with people, so you're going to have issues. But I think you got a lot less of an opportunity to have big problems like that. So we'll be focused on that toward the end of this first half of the year. And we'll get this information out. So I got a couple questions on here. I'm going to go ahead and answer those questions. If you have any other ones, please go ahead and send those in. So one question came up about so the state gets 75% after the lawyers 33% and are in control of the claim. Yes, that's true. It's absolutely insane that our state does it or did this before. But like I said, $1 million that employer is going to make, the attorney is going to make $330,000, and a whole class of employees can be involved that now split $250,000. Well, whatever's left. Actually, it's less than that. So yeah, it was ridiculous, and we have a very strong attorney lobby in the state. Now, I'm going to try to keep most of my opinions sort of light, but that attorney lobby spends a lot of money on our politicians in the state. We have one party rule. The attorneys support that party, and we end up with laws like this. Thankfully, and I'll give credit to Governor Newsom for signing this law. This is a really good opportunity for you to protect yourselves and from this what was a horrible law before. So yeah, somebody asked about any type of business insurance. Yes, EPLI. I'll get you information about that. Again, employment practice. Very expensive. Small businesses, if you don't have a 3-4 million payroll like our staffing company does, it might be $3,000, $4,000, $5,000, $6,000. Really not that expensive and worth every penny. And does Infinium timekeeping software allow for tracking of 10-minute rest periods? Yes, we do. We don't always recommend that you use the rest break tracking. It's not necessarily effective in preventing a lawsuit. Because as I mentioned, you're going to get a lawsuit that's based on usually something more serious, a meal break violation, overtime, work off the clock, those kind of things. Rest breaks are always just kind of thrown in. I've never seen a lawsuit that was predicated on missed rest breaks. So it's not something that we necessarily recommend that you do, because then the employees are clocking in and out like 8 times a day, which could become a little bit cumbersome and time consuming. We recommend more visible posters in the workplace, talking to everybody, making sure that you don't ever impede them as part of your handbook. Just make sure that is well known in the business. And I think that's it. So I want to thank you guys for attending today. I hope these are informative webinars that we try to put out. And again, we'll be just keep an eye on it. You can always go to our events page, and we're going to try to list the next 2 or 3 that are coming up. And please join us next time for that. If there's anything that we can help you with that you need in your business on the HR side, please reach out to myself. If you have HR, you've got Ann and Standfast to talk to. Please don't try to figure this stuff out on your own. Just get our advice. We'd much rather be a part of your research or whatever you're dealing with before it becomes a problem than after, because it's very difficult to fix after. So we're always here to help. We love helping our clients have better businesses and succeed with employees. So thanks very much. We're going to see you next month. Over and out. Have a great week. Bye bye.